It's Saturday and I wasn't really planning on doing a vlog today, but I saw a tweet that called me to action, so Mike Birbiglia.
Thank you very much.
Viva Frei, Montreal litigator turned YouTuber, and this is going to be a bit of a toned-down vlog because I've got somebody sleeping in the back. Now, Mike Birbiglia, for those of you who don't know, is a pretty funny stand-up comic. And for whatever the reason, I got notification of a tweet of his that just called me to action to do a vlog on a legal matter that I probably should have done a vlog on anyhow. For those of you who may not know, a decision just came down from the Supreme Court, a 5-4 decision which stayed the execution of an executive order coming out of New York as relates to religious institutions. Robert Barnes and I are going to talk about it during our next live stream, and I was thinking of maybe doing a vlog on it because my lawyer buddy Nate Brody sent me a copy of the judgment, and it is in fact a fascinating read. But then I saw a tweet from Mike Birbiglia and I knew what I had to do this Saturday. Mike Birbiglia, and he's got one of those illustrious blue check marks on Twitter.
Wow!
It is my religious right to not wear a seatbelt. Also, I can crash into other cars. Also, I can dump poison into my local reservoir. I'm sorry, but that's what my religion is. Anybody having followed my vlogs for long enough know that I often say politics ruin everything. I'm not wearing that shirt today. I'm wearing the chicanery shirt, but politics ruins everything, especially stand-up comedy. So I see this tweet from Mike Birbiglia and I get really irritated at the flawed analogy, total misunderstanding of the judgment coming out of the Supreme Court. At least I assume he is referring to that judgment or that precedent, and reading the comments in his comment feed, Twitter feed thing, I get the impression that no one responding actually knows what the case is about itself, and I feel compelled to respond as follows. Replying to Birbigs. Flawed analogy that only illustrates your misunderstanding of the subject. The court ruled that churches were being treated differently than secular institutions. A more accurate analogy would therefore be, quote, your religion allows for the prosecution of other religions, end quote. There are few things on this earth that irritate me more than willful ignorance, and one of those things is misleading other people. I don't know if it's deliberate or accidental, if it's based on a misunderstanding, but Birbiglia is misinforming the people that follow him. That's it. I got hot. I just got hot. Let's try to understand that analogy. Based on Mike Birbiglia's tweet, it would seem that his understanding of the situation is that the religious institutions who were petitioning for a stay of the execution of that executive order were asking for special treatment so that they can engage in conduct that was particularly dangerous, notwithstanding the rules that were applying to everybody else. And by the vast majority of the responses in his Twitter feed, it seems that a lot of his followers seem to feel the same way, when that is in fact the exact opposite of what is going on in this case. In this decision, it is the religious institutions who are arguing that they are being specifically targeted with harsher rules than that which apply to the secular world for no good reason at all. And although the Supreme Court decision in question does not adjudicate on the ultimate merits of that dispute, which is still ongoing, it suspends the execution of the executive order in the interim pending appeal. It is a 5-4 decision, and I've got to say, in my humble opinion, the 5 got it right in this particular instance. I'm not going to read the entire decision, I'm just going to read the majority opinion. Per curiam, Supreme Court of the United States. Roman Catholic Diocese of Brooklyn, New York versus Andrew M. Cuomo, Governor of New York. On application for injunctive relief, November 25, 2020. Per curiam. Before we even get into the decision, what does per curiam mean? In law, a per curiam decision or opinion is a ruling issued by an appellate court of multiple judges in which the decision rendered is made by the court, or at least a majority of the court, acting collectively, and typically, though not necessarily unanimously. In contrast to regular opinions, a per curiam does not list the individual judge responsible for authoring the decision, but minority concurring or dissenting decisions are signed. So this is the majority opinion of the court, and let's just see the highlights of what they say so that Mike Birbiglia can really understand what is actually going on here. The application for injunctive relief presented to Justice Breyer and by him referred to the court is granted. Respondent is enjoined from enforcing Executive Order 202.68's 10 and 25-person occupancy limits on applicant pending disposition of the appeal in the United States Court of Appeals for the Second Circuit and disposition of the petition for a writ of certiorari if such writ is timely sought. Should the petition for a writ of certiorari be denied, this order shall terminate automatically. In the event the petition for a writ of certiorari is granted, the order shall terminate upon the sending down of the judgment of this court. Okay, so what does this legalese mean in English? It means that the underlying case is currently under appeal, but that the petitioners have sought an injunction enjoining enforcement of the executive order in question, meaning that the executive order should not be enforced pending the appeal. If the appeal of the underlying decision is dismissed, or if the Supreme Court does not hear the case, or if it adjudicates on the case in a negative manner, then the stay of the executive order itself itself will be terminated. The bottom line is that while this case is still being heard on the merits, the executive order cannot be enforced in virtue of this Supreme Court decision. Then we get into a bit more of the context. Both applicants seek relief from an executive order issued by the governor of New York that imposes very severe restrictions on attendance at religious services in areas classified as, quote, red or, quote, orange zones. In red zones, no more than 10 persons may attend each religious service, and in orange zones, attendance is capped at 25. The two applications, one filed by the Roman Catholic Diocese of Brooklyn and the other by the Agudath Israel of American and affiliated entities, contend that these restrictions violate the Free Exercise Clause of the First Amendment, and they ask us to enjoin enforcement of the restrictions while they pursue appellate review. Citing a variety of remarks made by the governor, Agudath Israel argues that the governor specifically targeted the Orthodox Jewish community and gerrymandered the boundaries of red and orange zones to ensure that heavily Orthodox areas were included. Both the diocese and Agudath Israel maintain that the regulations treat houses of worship much more harshly than comparable secular facilities. And they tell us without contradiction that they have complied with all public health guidance, have implemented additional precautionary measures, and have operated at 25% to 33% capacity for months without a single outbreak. So you see, Mike Birbiglia,
If that is in fact your real name,
and if you are in fact even watching this, that the religious institutions are not asking for special treatment. They are just asking to be treated equally to the secular institutions. And wait until you find out just how harsh and disproportionately excessive the regulations were as relates to these religious institutions compared to their secular counterparts. The applicants have clearly established their entitlement to relief pending appellate review. They have shown that their First Amendment claims are likely to prevail, that denying them relief would lead to irreparable injury, and that granting relief would not harm the public interest. Because of the need to issue an order promptly, we provide only a brief summary of the reasons why immediate relief is essential. And because this is an injunction, the court then goes through the criteria that are necessarily need to be met in order to grant the injunction. You want to go in the house? I'll be back. Okay, now we can get back to the normal tone and pace. Because this is an injunction, the court then gets into the criteria that need to be met in order to grant the issuance of the injunction, the first of which is likelihood to succeed on the merits. The applicants have made a strong showing that the challenged restrictions violate, quote, the minimum requirement of neutrality to religion. As noted by the dissent in the court below, statements made in connection with the challenged rules can be viewed as targeting the, quote, ultra-Orthodox Jewish community, end quote. But even if we put those comments aside, the regulations cannot be viewed as neutral because they single out houses of worship for especially harsh treatment. Going back to Birbiglia's tweet, this is not a case of religious institutions asking for special treatment, asking not to be subjected to the rules. You're going to see how harsh the rules are that were being imposed on religious institutions compared to other essential services. And because I already hear some of you saying, but religious institutions are not essential services, the court does address this point a little later on, and yes, they are essential. In a red zone, while a synagogue or church may not admit more than 10 persons, businesses categorized as, quote, essential may admit as many people as they wish. And the list of, quote, essential businesses includes such things as acupuncture facilities, campgrounds, garages, as well as many whose services are not limited to those that can be regarded as essential, such as plants, manufacturing chemicals, and microelectronics, and all transportation facilities. This disparate treatment is even more striking in an orange zone. While attendance at houses of worship is limited to 25 persons, even non-essential businesses may decide for themselves how many persons to admit. Hey, Birbiglia, you think your analogy is on point? Because I don't think a great many people would think so knowing the facts of this case, but moving on. These categorizations lead to troubling results. At the hearing in the district court, a health department official testified about a large store in Brooklyn that could, quote, literally have hundreds of people shopping there on any given day, end quote. Yet a nearby church or synagogue would be prohibited from allowing more than 10 or 25 people inside for a worship service. And the governor has stated that factories and schools have contributed to the spread of COVID-19, but they are treated less harshly than the diocese church and Agudath Israel synagogues, which have admirable safety records. The court then goes on to explain that given that the restrictions that are challenged are not neutral, that the applicable standard of review is that of strict scrutiny, and this is what they mean by that. Because the challenged restrictions are not, quote, neutral and of, quote, general applicability, they must satisfy, quote, strict scrutiny, and this means that they must be, quote, narrowly tailored to serve a, quote, compelling state interest. Not only is there no evidence that the applicants have contributed to the spread of COVID-19, but there are many other less restrictive rules that could be adopted adopted to minimize the risk to those attending religious services. Among other things, the maximum attendance at a religious service could be tied to the size of the church or synagogue. And if you truly want to appreciate how absolutely arbitrary and not narrowly tailored these restrictions were, just wait until you hear the maximum occupancy of these various religious institutions or entities. Almost all of the 26 diocese churches immediately affected by the executive order can seat at least 500 people. About 14 can accommodate at least 700, and 2 can seat over 1,000. Similarly, Agadah Israel of Kew Garden Hills can seat up to 400. It is hard to believe that admitting more than 10 people to a 1,000-seat church or a 400-seat synagogue would create a more serious health risk than many other activities that the state allows. In order to grant injunctive relief, the petitioner has to show irreparable harm. And what would be the irreparable harm from not being allowed to practice your religion?
The irreparable harm would be not being allowed to practice your religion.
Irreparable harm. There can be no question that the challenged restrictions, if enforced, will cause irreparable harm. Quote, the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury, end quote. If only 10 people are admitted to each service, the great majority of those who wish to attend Mass on Sunday or services in a synagogue on Shabbat will be barred. And while those who are shut out may in some instances be able to watch services on television, such remote viewing is not the same as personal attendance. Catholics who watch a Mass at home cannot receive communion, and there are important religious traditions in the Orthodox Jewish faith that require personal attendance. The court then goes on to dispatch of the public interest argument by obviously coming to the conclusion that there is no compelling public interest to justify these measures on these religious institutions where they don't apply to essential services or other businesses. Public interest. Finally, it has not been shown that granting the application will harm the public. As noted, the state has not claimed that attendance at the applicant's services has resulted in the spread of the disease, and the state has not shown that public health would be imperiled if less restrictive measures were imposed. The majority of the court then goes on to dispatch of the dissenting argument that the question has become moot. We have seen this same argument made elsewhere in Pennsylvania. I think it was made in Michigan, but the court dispatches of the argument for the very same reason. The dissenting opinions argue that we should withhold relief because the relevant circumstances have now changed. After the applicants asked this court for relief, the governor reclassified the areas in question from orange to yellow, and this change means that the applicants may hold services at 50% of their maximum occupancy. The dissents would deny relief at this time, but allow the diocese and Agadah Israel to renew their requests if the recent reclassification is reversed. There is no justification for that proposed course of action. It is clear that this matter is not moot, and injunctive relief is still called for because the applicants remain under a constant threat that the area in question will be reclassified as red or orange. The governor regularly changes the classification of particular areas without prior notice. If that occurs again, the reclassification will almost certainly bar individuals in the affected areas from attending services before judicial relief can be obtained. For these reasons, we hold that enforcement of the governor's severe restrictions on the applicant's religious services must be enjoined.
It is so ordered.
This was the exact same argument raised, I think it was in the Pennsylvania decision, but it was raised in other cases where they said the stay-at-home orders are no longer in effect, so there's no longer any reason to adjudicate on that question. And the judge said, no, to the extent that you can reimpose those stay-at-home orders at any time, we need to adjudicate on it now. The dissenting opinion said the same thing in this case. There's no need to adjudicate on it because they've been reclassified as yellow, so they're not living under the orange or red zones now, so there's no harm. And the majority rightly said, no, you cannot continue living under the proverbial sword of Damocles. You need to have your freedoms now, and you need to know that you have your freedoms now. To be seen what happens with the merits of this decision, because bear in mind, this is just a judgment on the interlocutory injunction that wants to prohibit enforcement of the executive order. It is not a judgment on the merits, but the majority of the Supreme Court has certainly given an indication as to which way they are leaning on the merits. But that is the judgment. It was never a question of religious institutions asking for special treatment. They were just asking to not be especially targeted by harsh restrictions that don't apply to the secular world. And Mike Birbiglia, as they say,
Now we know.
And knowing is half the battle.
With that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
Please, sir, I want some more.
If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, Patreon, subscribe to our YouTube membership. We've got merch. Be sure to follow me on Rumble, which is sort of like YouTube without the chicanery. Be sure to watch the weekly live streams I do with Robert Barnes every Sunday night at 7 o'clock. They are eye-opening to many. And with that said, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah!